Hi, I'm Shan Wu with a Under Color of Law update on the nomination of the U.S. Attorney for the District of Columbia, my old office, Ed Martin. Now, let me be upfront here. I think Ed Martin is the least qualified nominee for any U.S. Attorney position in history. But right now, his nomination looks like it's on thin ice. If you remember, he's the guy, we'll talk about some of his other characteristics, but he had the conflict of interest, extraordinary one, where as the interim prosecutor in D.C., he dismissed the case against a January 6th defendant who he also represented. Kind of no-brainer. You can't do both sides of that, right? So that's Ed Martin. Now, the Senate Judiciary Committee has again put off a vote on whether to hold a hearing on his nomination. Remember, he was a organizer of the Stop the Steal event, at which he says he was present on January 6th and he, Ed Martin, did not see any evidence of violence. So committee members are continuing to review the information about him. The Senate Judiciary Chairperson, Chuck Grassley, Republican of Iowa, he said that he was going to wait to put Martin on the agenda to give members and staff time to review the responses to the hundreds of questions. Now, Senator Dick Durbin, he's the top Democrat on the Judiciary Committee, has already made his view quite clear, saying that he really thinks that this is unquestionably a bad nomination. And we'll get into some of the specifics about that a little bit later. He says, though, a potential hearing vote's still on the table, but he's going to take a good faith effort to let people look at the responses. But Durbin also said, quote, after people review the responses, quote, I think they'll come to the same conclusion I've come to. He is not qualified for this position. Among the reasons Durbin gives for that is that Martin's responses, there are these huge questionnaires you have to do for these kinds of positions. Senator Durbin says that Martin's responses show he made false and contradictory statements to the committee. And he also put down Martin for failing to disclose 400 past public appearances in his original questionnaire. Durbin said that's virtually unprecedented in the history of the committee that he served on for nearly 20 years, and somebody would fail to disclose that many of the media appearances. Many of those media appearances actually took place on Russian state television. Maybe that's why he didn't want to disclose it. Now, Russian state television is not an independent network. Unlike us, we are very independent. We aren't beholden to the state. We aren't beholden to corporate overlords, and that's why hit that subscribe button. We're trying to build this presence. We're getting there with your help, and make sure that you take this journey with us right now. Now, going back to Ed Martin and the Russian media appearances, for example, about a month before the Ukraine invasion, Martin was on their state media, and he was asked on Russian TV about a U.S. State Department warning that the Russian media he was on were, quote, critical elements in Moscow's propaganda and disinformation efforts. Martin sided with the Russian networks, saying that they, meaning the U.S., weaponizes this kind of crap. This is, quote, big tech and big media are backed up by big government, and they're forcing the message. Basically, he's disagreeing. Kind of reminds you of Trump agreeing with Putin, right? Way back when. No reason not to disbelieve them. So here he is agreeing with the Russian state-sponsored media that they are not tools of propaganda. Now, there's no illegality for him going on a state-sponsored television station. That's fine. He can do that. He has a right to say what he wants. He has a right to go on where he wants. But he does have a duty to disclose this information on these sworn disclosures. Now, you might be asking, well, isn't he going to get in trouble? False statements, he failed to disclose things. Yes, but the key is he can amend these disclosures, and that's what's going to get him out of the problem of having made false statements or false omissions, because omissions can also get you in trouble under 1001 liability. So he is frantically trying to amend all of these media appearances. Another characteristic of his, which is particularly important, is his approach towards prosecution. Now, Martin has never been a prosecutor, okay, so perhaps he can be, forgiven for not understanding some of the basic nuances to it, but he has been a defense counsel. So he should really understand the importance of when a witness or when a police officer has conduct in their past or cases that could exhibit bias. In DC, we call that Lewis information. So let's say you're a prosecutor, you're putting on a police officer who's been previously investigated for lying under oath. He's been also investigated for unjustified force. Issues that have arisen, a list is kept so that the prosecutors know which police officers may have questions when they are called as a witness. And that type of information is bias information, meaning the officer may be biased. It may be Brady information, meaning it could help the defendant prove innocence, not prove innocence, but argue that he's innocent. That has to be disclosed to the defense counsel. So you'd think Martin would understand the value of that, right? Because if you don't disclose it, it calls into question whether the prosecutor is hiding the ball. There's stuff that could be contrary and bad for the case that they're hiding. But Martin has said that he is rewriting this policy for the U.S. Attorney's Office. It's what we would call the Lewis List, named after a case, which is a repository of police officer disciplinary records. And the prosecutors consult that list when they decide whether to put an officer on the stand, and they have to use the list to identify which officers they have to disclose the kind of information to the defense counsel. So Martin should understand that, but he wants to rewrite it because he says he's going to reform that list because, quote, the U.S. Attorney's Office will no longer allow judges or others to gratuitously damage your careers, meaning the police, because of the outsized impact of inexact characterizations. Now, what is he talking about? He's not going to allow judges to gratuitously damage your careers? The judges aren't the ones that damage the careers. I mean, it's what the internal investigation showed. It's not up to him to, after the fact, decide, oh, this is just nonsense. Anything that is damaging to the police, we're going to say simply didn't exist. Let's just make it up, make it go away, hide it. Now, here's another problem with that, right? As an excellent ProPublica summary did here, they pointed this out. When you get rid of this Lewis list, when you get rid of the ability to disclose these things for prosecutions, it makes the prosecutions that are obtained, that do obtain a conviction, they're more vulnerable on appeal. So you can get convictions reversed on appeal because you did not disclose problems with the case, like the discipline problems particular officers may have had. It can even hurt the prosecutor's law licenses because they have a duty to be ethical and to have candor towards the court. So without revealing this kind of information, undercuts both the convictions as well as the ethics of the prosecutors. So that's a great example of the approach Ed Martin wants to take towards being the chief prosecutor in DC. What else has he been up to? Well, he's also targeting medical journals. He wants to question whether they are misusing their information. In one of the letters he sent to the American College of Physicians, he says, you're being partisan in various scientific debates. And he asked a series of questions such as, how do you clearly articulate when you have certain viewpoints that are influenced by your ongoing relations with supporters, funders, and advertisers? Several medical journals have received similar kinds of letters. And you just have to wonder, what is his basis for doing this? He's the U.S. Attorney in D.C. He's taking this national approach towards generally considering the viewpoints of medical scholarly publications. And lastly, let's not forget, among the other things he's targeting is Wikipedia. So he sent a letter to Wikipedia saying he wants to determine whether their behavior is in violation of their tax-exempt 501c3 status. He wants all sorts of detailed information about its editorial process, its trust, safety measures, and how it protects its information from foreign actors. And his allegation is Wikipedia is permitting information manipulation, including the rewriting of key historical events and biographical information of current and previous American leaders. Okay, if you've ever looked at Wikipedia, it's all about the rewriting, right? It's a crowdsourced type of document about particular people from around the world. So, of course, there are going to be foreign actors involved in that. It makes no sense what he's saying, although it does make a whole lot of sense if maybe he's jealous that he doesn't like his Wikipedia listing very much. But he wants to claim that Wikipedia is masking propaganda that influences public opinion under the guise of providing informational material. I don't think Ed Martin is the right guy to trust to recognize propaganda when he sees it. So that's it for now. Let's keep an eye on the Ed Martin nomination and see whether this is a particular hill that Republicans are willing to die on for it. I think it's going to be a little bit problematic for Ed, but we'll find out. So keep on watching us. Keep on commenting. Love to get those comments. Do my best to reply to them when I can. And do follow me on Blue Sky, and we'll be talking to you soon.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.